There are professions that require an act of trust so complete and so vulnerable that most people never fully appreciate what they are asking. Nursing is one of them. When a patient is at their most helpless, sedated, unconscious, dependent on machines and medications and the people who administer them, they have no choice but to trust. They cannot watch. They cannot verify. They place their body and their life entirely in the hands of someone they may have met for the first time that morning. Amara Osei had spent 20 years being worthy of that trust. 20 years of night shifts and difficult families and patients who recovered and patients who did not. 20 years of the particular combination of clinical precision and human warmth that makes an exceptional nurse. She was 44 years old when a colleague made an accusation that destroyed everything she had built. The accusation was that Amara had deliberately administered an incorrect medication dosage to a patient who subsequently died. That it was not an error. That it was intentional. Amara had made no such error. The patient's death, a 68-year-old man named George Whitfield, was the result of a previously undetected cardiac condition that had nothing to do with his medication. The post-mortem would eventually confirm this. But the post-mortem came 2 years after the conviction, and Amara spent those 2 years in a British prison for a murder she had not committed, watching her career dissolve and her family struggle with the weight of an accusation that the medical evidence had never adequately supported. This is the story of a nurse. Amara Osei had come to England from Ghana at the age of 19, following an aunt who had worked in the NHS for a decade and had suggested that nursing was a path worth considering. Amara had considered it and decided it was more than a path. It was a calling, in the specific sense that it matched who she was at a level that most people spend their lives searching for. She had trained at a London teaching hospital, qualified at 22, and spent the following 22 years working across 3 NHS trusts, primarily in cardiac and general medical wards. She was the nurse that junior staff came to with questions. She was the nurse that difficult families asked for by name. She was the nurse who stayed late not because she was required to but because leaving felt wrong when there was something unfinished. She had a husband, Joseph, who drove for a logistics company, and 2 daughters, 15 and 12 at the time of her arrest. They lived in a semi-detached house in Coventry that she and Joseph had bought in 2009 and were paying off with the careful economy of 2 people who understood that what they had built was worth protecting. She had never been the subject of a disciplinary complaint. Her annual appraisals were uniformly positive. The ward sister who had supervised her for 7 years described her, in a later statement, as the best nurse she had worked with in 30 years of NHS service. George Whitfield had been admitted to Amara's ward on a Tuesday in March 2018 with a diagnosis of chest infection. He was 68, overweight, a former smoker with a history of mild hypertension. He was not considered high risk for cardiac events. He was expected to be discharged within. Sandra Pierce was 49 years old in March 2018. She had worked on the same ward as Amara for 11 years. She was competent, experienced, and had been passed over for a senior charge nurse position twice, both times in favor of candidates who, in the opinion of the ward management, were better suited to the role. Amara had been one of those candidates 3 years earlier. What Sandra had built up over those years, not visibly, not in ways that ever triggered a formal complaint, was a specific resentment. The kind that lives beneath the surface of professional courtesy and expresses itself in small ways that anyone who experiences it knows are deliberate, and anyone who doesn't experience it cannot quite see. She had, in the days after George Whitfield's death, spoken to his family. She had told them that she had concerns about the medication administration on the evening he died. She had implied, carefully, with the plausible deniability of implication, that Amara had administered something outside the prescribed parameters. George's daughter had gone to the hospital management. The hospital had launched an internal investigation. The investigation had reviewed the medication records, which showed no discrepancy, and had found no evidence of error. They had concluded that George's death was consistent with his underlying health profile and had referred the matter to the coroner. Sandra had then gone to the police. She told them she had witnessed Amara administer what she believed was an incorrect dosage on the evening of George's death. She said she had seen it and had been uncertain whether to report it until the patient died. This was a lie. Sandra had not been present at the medication administration. She had been on a break. This was documented in the ward's electronic staff movement logs, but the police, in the initial investigation, did not examine those logs carefully. They examined the medication records, which were ambiguous enough to permit the theory, and they examined Sandra's statement, which was specific and confident. Amara was arrested on a Tuesday morning in May 2018, 2 months after George Whitfield's death. She was questioned for 6 hours. She denied everything. She gave a clear and detailed account of the medication administration that was consistent with the records. She said Sandra had not been present. She said she did not know why Sandra was saying what she was saying. She was charged with gross negligence manslaughter. The charge was later upgraded to murder. The trial of Amara Osei opened at Birmingham Crown Court in October 2019. It lasted 4 weeks. The prosecution's case rested on Sandra Pierce's eyewitness testimony, a medical expert who testified that the medication administration could, under certain reading of the records, have been outside prescribed parameters, and a theory of motive, that Amara had been under pressure from ward targets and had, the prosecution suggested, made a decision that prioritized throughput over patient safety. The motive theory was, as motive theories in wrongful conviction cases so often are, thin to the point of transparency. Amara had no history of any practice concern. The suggestion that she had killed a patient to meet a ward target required the jury to believe something that her entire 20-year career contradicted. But Sandra was there. Sandra had seen it. Sandra had 20 years of NHS experience and spoke with the authority of someone who knew what the medications were and what the records meant. The jury heard a medical expert for the prosecution and a medical expert for the defense disagree about whether the records were consistent with correct dosage. They heard Sandra say, "I was there. I saw it." What the jury did not hear, because it had not been found, was the electronic staff movement log showing Sandra's break at the precise time she claimed to have witnessed the administration. The defense team had requested staff records, but had received a partial disclosure. The log file containing the break records had been provided in a format that required specialist software to read, and the defense's IT consultant had been unable to access it before the trial date. Amara took the stand. She was precise and clear. She described everything. She said Sandra had not been present. She said she did not know why Sandra was saying what she was saying. She said George Whitfield had been alive and responsive when she completed her medication round. The jury deliberated for 5 days. They found Amara Osei guilty of gross negligence manslaughter. She was sentenced to 8 years. She was 45 years old. Her daughters were 16 and 13. Joseph Sadden. Amara Osei entered HMP Foston Hall in Derbyshire in November 2019. She was the first person in the facility's population, to her knowledge, who had been convicted of killing someone in their professional care. This distinction, the specific nature of the accusation, made her imprisonment different from the first days. She adapted. She had spent 20 years adapting to difficult environments, night wards, under-resourced departments, families in crisis. She applied the same discipline. She kept her head down. She was, by the accounts of prison staff who later gave statements, cooperative, quiet, and visibly distressed in a way that never became disorder. Joseph brought their daughters to visit monthly. The visits were, by everyone's account, the most difficult thing any of them did. The daughters were 16 and 13. They were old enough to understand precisely what the conviction meant for their mother's career, for their family's reputation, for the ordinary things, school, friends, explaining where their mother was. That became impossible. Amara filed an appeal in March 2020. It was refused. She filed again in November 2020. Refused again. What changed things was not a legal appeal. It was a retired NHS clinical governance officer named Dr. Ruth Patel, who read about the case in a medical ethics journal in January 2021 and noticed something in the description of the medication records that made her stop. Dr. Patel had spent 30 years reviewing clinical incidents for the NHS. She knew medication records. She knew what they looked like when they were correct and what they looked like when they were ambiguous for reasons other than error. She read the journal description carefully. Then she obtained, through a Freedom of Information request, the original documentation. And she found, in the original records, that the prosecution's medical expert had misread the timestamp format used by Amara's hospital's electronic prescribing system. The medication had been administered. The timestamp format difference that Dr. Patel identified was, in isolation, a small technical matter. The hospital's primary prescribing system used a 24-hour clock format. The secondary medication administration record used a 12-hour format. The two systems, when their records were cross-referenced, created an apparent discrepancy of exactly 12 hours. The prosecution's medical expert had cross-referenced the two systems without accounting for the format difference. This had made a medication administered at 8 in the evening appear to have been administered at 8 in the morning, 4 hours before the prescribed time. The apparent early administration had been the foundation of the prosecution's medical evidence that something incorrect had occurred. The hospital's 2017 IT report, which had documented this known discrepancy and recommended a system update, had been in existence throughout the investigation and the trial. It had not been disclosed to the defense. It had not been available to the prosecution's expert. It had been sitting in the hospital's internal document management system, filed under IT infrastructure, invisible to anyone who was not specifically looking for it. Dr. Patel obtained a copy through her Freedom of Information request. She provided it to a medical negligence solicitor she had worked with previously. The solicitor contacted Amara's original defense team. Amara's defense team contacted the Court of Appeal quashed Amara Osei's conviction in May 2022. She had served 2 years and 6 months of her 8-year sentence. She walked out of HMP Foston Hall on a warm May morning. Joseph was there. Both daughters were there, 18 and 15 now, older by 2.5 years than when she had gone in, changed in ways that prison visits had shown her but not fully prepared her for. Her older daughter, Maya, had done her A-levels during Amara's imprisonment. She had applied to study nursing. She had been accepted. She had deferred her place until her mother was free, so they could mark the moment together. Amara stood in the car park and held her daughters and looked over their shoulders at the sky and said nothing for a long time. Then she said, "Maya, you're going to be a wonderful nurse." Maya said, "I know. I had a good teacher." Sandra Pierce pleaded guilty to perverting the course of justice in September 2022. She was sentenced to 4 years in prison. The hospital trust issued an apology to Amara. Sandra Pierce was released from prison in 2024, having served 2 years of her 4-year sentence. She has not returned to nursing. The Nursing and Midwifery Council struck her off the professional register in 2023. The hospital trust's internal review of its disclosure practices identified 14 instances over the preceding decade where electronic documentation had not been provided to legal proceedings in a format that was accessible to defense teams. The review resulted in a new disclosure protocol. It was, the trust's chief executive said in the report, a necessary and overdue improvement. Amara Osei received compensation from the Criminal Injuries Compensation Authority and pursued a civil claim against the hospital trust. The civil settlement, reached in 2023, was undisclosed in amount. She has not returned to nursing. She says this not with bitterness but with realism. The NMC, while acknowledging her exoneration, required a fitness to practice review before she could return to the register. The review was granted, but by the time it was concluded, Amara had already made a different decision. She works now as a patient advocate, a role that exists in the space between healthcare and the legal system, helping patients and families understand their rights, navigate complaints, and find the questions they need to ask when something has gone wrong. She is, by the accounts of everyone who has worked with her, exceptionally good at it. This should surprise no one. Her daughter Maya is in her 2nd year of nursing training. Amara attends her university open days. She sits in the back row and does not identify herself as Maya's mother because she does not want to complicate Maya's experience with her own story. She just watches. She watches and she thinks about 22 years and what they add up to, and about what it means to pass something on to someone who will carry it forward. She was asked, in an interview with a healthcare ethics journal, what she wanted the medical and legal professions to understand from her experience. She thought for a long time. Then she said, "I want them to understand that the evidence matters more than the narrative. I want them to understand that a confident witness is not the same as an accurate witness. I want them to understand that documentation, electronic records, timestamp formats, IT infrastructure reports, is not administrative background noise. It is the evidence. And if you do not look at it carefully, completely, and with the specific knowledge required to read it correctly, you will miss what happened." She paused. She said, "I spent 20 years reading evidence carefully. They did not extend me the same courtesy."